Morning, everyone. It is approximately 5 after 9. We have a quorum present. The first order of business is a roll call. Jack, can you start? The microphones have been changed. You have to push and hold the button to speak. When you release it, it disconnects.
Okay, I thought it was an Aggie. Jack Upmore, residential contractor.
Mike Rust, R2 Residential.
Andre Garrett, Beacon Fire Protection Engineer.
Brian Smith, Residential Contractor.
Edna Geckler, representing the Building Owners and Managers Association.
Rod Olivier, Electrical Engineer.
Chris Garcia, Mechanical Engineer.
Robert Hanley, Architect.
Liddell Toy, Master Sign Electrician.
Mike Leonard, Commercial Building Contractor.
Tim Curley, Master Electrician.
Randy Hunter, Master Plumber.
First order of business is approval of the minutes from the last meeting, which was on December the 9th of last year. Is there a motion to accept the minutes?
Move approval.
Mr. Hammond has made a motion to approve.
Second.
Is that you, Brian?
Yes, sir.
Mr. Russ has seconded. There's a motion on the floor to approve the minutes of the December 9th meeting. All in favor, please say aye.
Aye.
All opposed? Before we start the remainder of the meeting, there's a couple of procedural issues we need to discuss. The way these deals are handled is the city will state their position, the appellant will state their position, we'll accept comments from the public, from those who have signed up. Public comments are limited to 3 minutes apiece. You cannot pass your time on to anyone else. You're followed up by a summary by the city. And when you speak, please say your name so that when these records are kept, we'll know who the speaker was. Since this is a fairly long appeal document, I'd like Mr. Murphy to address the board. Mr. Murphy is the city attorney. That's our board advisor.
Good morning, board. Ted Murphy, Development Services, Legal Liaison, to the board. I did want to talk to you briefly about what your requirements and what your duties are here today. I know that there was a little bit of confusion as far as the length of the packet is concerned. The board's authority is, in this particular case, specific to Chapter 10. Okay. There's no legal authority here for you to address anything regarding Chapter 35. Okay. The other thing I wanted to mention here is that you may not waive any of the requirements of Chapter 10. We're here specifically to answer an appeal. The appellant here is not the applicant. The applicant, All Texas Electrical, was granted an electrical permit. The appellant here is contesting granting that permit. The only thing that you need to address here was the electrical permit issued to All Texas Electrical in violation of Chapter 10. If an applicant, any applicant, meets the requirements, Chapter 10 requirements, the director must issue the permit. Mr. Shannon is going to give a presentation on exactly what that process entails, what the requirements are for that particular electrical permit. Burden is on the appellant here to show that the issuing of the electrical permit is in violation of Chapter 10. I've already been given a brief description of the appeals process, what happens who goes first, who goes last, that kind of thing, and your deliberations. If you have any other questions or concerns, I'm happy to address them.
Do any other members of the board have questions for Mr. Murphy? Thank you.
Chair, I'm sorry, Ted, I got one. When you said chapter 35, that would be,
UDC plan.
when you're referencing chapter 35, that would be the zoning issues.
That's correct.
Mr. Shannon?
Thank you, Mr. Chairman and board members. For the record, I'm Mike Shannon, Assistant Director with Development Services. I'm here today to kind of talk to you about the electrical permit that was issued in March that we're here today that the appellant is appealing. So again, as Ted indicated, you're here as the board to talk about whether or not we've issued the electrical permit to All Texas Electrical on March of this year, March 18th. It was actually a completion permit, and I'm going to talk about that a little bit here in a second. So, just a little history of this project. This is a project that's related to a building permit. This is not a standalone electrical permit. An existing building is being renovated. They have building permits that were issued in or around August of last year. So the typical process, as you all know, is the property owner submitted plans to us, construction documents for an ambulatory care facility. That was reviewed through our normal plan review and permitting process, and in August, we issued building permits for that because we believe it meets all the city applicable codes. Okay. Certainly after that, we issued trade permits, right? The typical trade permits would be mechanical, electrical, plumbing. Those are typically generally licensed contractors. That is verified through the permitting process to those trade contractors. And in doing that, they then will install per the approved set of plans, the permitted set of plans. And that was going along since August and all through last year. So as this project is under general construction and inspections are happening, the Development Services was notified in March that All Texas Electrical wanted to apply for a change or a completion permit. One of them being this elevator permit. They are the contractors that are installing it and going to get the inspection. So the completion permit, and I use the term completion permit, was issued in March. And a completion permit, if you haven't heard the term before, or we call it a completion permit, the way to describe a completion permit is anytime a particular contractor, a general contractor or trade contractor starts the job, and there is a change. It could be any reason for a change. And many of you are in the industry, you understand this, that contractor A is no longer there, and it happens in the middle of the project, anywhere in the middle of the project after the original permit was issued. Contractor A quits, contractor A gets fired, contractor A gets sick and can't finish it, or, heaven forbid, passes away. These are all things that have happened. They tend to happen through the course of business and construction and permitting. And in this particular case, All Texas actually had a change to their master electrician, so they wanted that recorded through our completion permit. So what we do is when there is a change like that, we issue a completion permit. There's an application for it, and they communicate with the city saying, here is the change. And we'd like to, we've got to a certain point, and there have been inspections on that permit, but it's not been final. We create a new permit number. You'll see that the permit number that they're appealing is C2048862. The C is our way internally of recognizing that permit number is a completion permit. And that starts off where the other permit ended. So we have in our record, and if there's two contractors, or in this case, the same contractor with different licensed and state licensed personnel, the record shows who started it and who finished it. So during that process of a completion permit, we then look at, Development Services goes through our typical permitting process for that subcontractor, in this case, the electrical contractor. And we verify again that they're licensed and registered with us per our city code. We have verifying that they have the proper insurance requirements to obtain the license, that nothing has expired, and that they're going to finish the job with the approved or permanent set of plans that were issued back when the project was permitted as a whole back in August. So it's a fairly standard procedure. There are some checks, though, that we do. We verify that that new contractor or the new information present does meet our city code. And specifically, if you look at, we have in Chapter 10, we have Section 10-6. That's the section on permits. So if they meet code, we have to give them the permit, right? We can't say no if we could, just for any particular reason. If they meet code, we give them the permit. It's in Section 10-113, which is part of the licensing and registration requirements of our code. I think most of our contractors are very aware of that. That's what says if you're a contractor, an electrical contractor, mechanical plumber, whatever, you do have to get licensed and registered, not only through the state, but with the city, so we can verify and you get renewed every couple of years, depending on the particular license. So a lot of those items, all of those items were reviewed when this permit was issued for the elevator, the completion permit for the elevator. And just to give you some context, that this is a very common occurrence, or it's common enough. Since January 1 of this year, so in this calendar year so far, so just a few months into it, we've already issued approximately 101 of these completion permits. Okay, so it's not that unique. It happens. I think those of us in construction know that this happens every now and then. Certainly, some of them, 40 of those have been electrical permit approximately. In the calendar year, last calendar year, 2014, we just did a quick survey of what we had. We have 350 completion permits in our system. So again, while it's frequent enough and it's not uncommon, but this is our process. They certainly met code to issue this permit, and the city followed all of the Chapter 10 requirements as laid out. So that's really my presentation to start off. I can answer any questions. We'll go to the next speaker.
Are there any questions from the board?
It's Mike Liddell Toy. So just to summarize, the master of record has been changed, and has this project been finalized, or are they still under construction?
It has not been finalized. It's still under construction. I understand it's fairly close to being finalized, but it's not fully there yet.
And Mike, Andre Garabedian, my question on continuation permits. So as long as the original permit was filed and plan review was completed with a specific use or occupancy, and there is no change in that use of occupancy or occupancy from the original permit, the continuation can be granted.
Well, correct. I think the answer is when contractor, I'll call him contractor B, or whatever that change is, comes in and they say, here's my new information, or I'm the new contractor on it, I want to finish that project that you've already approved and permit. If they were to tell us they wanted to change the design or change something, well, that would have to be re-permitted or plan reviewed again, but in this case, there was no indication that there was going to be any change of any of the design. It's just that the contractor information changed, so that's why we issued that completion permit.
Thank you, Mike.
Okay, thank you.
Mr. Chairman, it's Andre Garabedian. Now that I've had some more time to understand the direction given by Councilor Murphy, I'd like to ask a question on that. If you could. So again, the package that we have before us is really heavily leaning towards a discussion on Chapter 35.
That's correct.
So in looking at Chapter 10 only and the issuance of a permit, in Mike's direction regarding what the city does when they receive the original plans for review, they issue a permit for the first contractor and it goes to the second contractor. I guess if there is an appeal on whether that first permit was valid the way it was, and that appeal brings in some issues with Chapter 35. Does our decision on the Chapter 10 determination have to rely on the Chapter 35 information?
It's a very interesting question. I'm not sure I can readily answer that.
So in the context of my previous question to Mike, continuation, just like in other instances with the city, may be a point for reconsideration. And the example I gave is if there was a change in use of a facility, meaning the original permit was done as a school and it changed to a gasoline storage warehouse, it might be worth going back and reevaluating the permit submittal process. And a continuation permit might be a good time to go back and look. So if we could take a couple of minutes just to understand the direction that the board should follow in looking through a lot of the Chapter 35 stuff, which I've researched, versus Chapter 10 stuff, which appears to be the context of where we're at.
What is your direction?
The question is, if the appellant says that there was a misunderstanding in the determination of zoning, and that this continuation permit further exaggerates that misunderstanding, is now the time to reevaluate that.
If I could have this, please. I had a sidebar conversation with my colleague that this is when the issue that you're describing here was decided in August. That issue has been decided. We're here specifically for Chapter 10. The issue is whether or not, again, was the electrical permit issued to all Texas Electrical in violation of Chapter 10?
You mentioned that the other issue has already been discussed and resolved.
Involved apparently another human August.
Give me a second, I'm trying to think of whether we should know the results of that or whether it even matters. So, proceed
No.
with the questions.
Mr. Murphy, just for purposes of understanding this, if there is another issue here at the city that has not been resolved, in response to Mr. Garavia's question, that's really not important. If that issue is not resolved, can we resolve Chapter 10 or do we have to continue? Because I'm wondering about the conflict based on the action that we as a committee would take if the other issue is not resolved.
That's a hypothetical in whether or not the decision today has any bearing on a decision later or something that has not occurred.
Okay, that's what I need. Thank you. Thank you.
Are there any other questions or issues? Have I resolved your question?
Yeah, I'm fine, thanks.
Sure.
Other question for the appellant? Thank you.
Can you hear me? Thank you, Mr. Chairman. Mr. Chairman, honorable members of the board, I am Dennis Driyar. I am an attorney here in San Antonio, and I am representing the appellant in this case, who is Lori Rojas. Ms. Rojas, would you please see? Thank you, ma'am. First of all, I would like to thank you for your time. I know it's very early. I know everyone has other things to be doing, and yet I'm sure you can appreciate from all the stakeholders with whom you may have dealt with either in your personal, professional lives or on this board, that these matters are very important to people. They're very important to be adjudicated, and they're very important to have resolution. Whether we're in court on jury trials or whether we are using citizen boards or citizen city council, it is very, very important to citizens to have peaceful resolutions to these matters. And so, honorable members of the board, you hopefully will be able to adjudicate this matter and provide a peaceful resolution. I think it's already been referenced by the DSD Assistant Director as well as by Mr. Murphy that this is an unusual appeal. Now, I know Mr. Murphy personally as well as professionally, and he's a very able attorney. And as an advocate for his client, or as an advocate or advisor for this board, he has a role to play. And I think I understand that, and my client understands that. Respectfully, if everything were clearly black letter, there would not be a need to have lawyers with differing viewpoints. I think there have been questions about the interplay between Chapter 35 and Chapter 10. And hopefully, honorable members of the board, I will be able to provide some insight on that and explain why I think that our appeal for Chapter 35 actually is directly implicated by Chapter 10. Specifically, Mr. Murphy was indicating that if it is that you are to decide whether or not something is in violation of Chapter 10. So if you would permit me, let me walk through a few provisions of Chapter 10 code. And I'm sorry I don't have them here, but I'm just not going to take a lot of time. I'm just going to quote some provisions from Chapter 10. First of all, I am at Section 10-1B. And in Section 10-1B, it reads, "The building official shall be known as the Director of Development Services, and such terms shall include his authorized representatives." And it goes on to talk about what those authorized representatives are. That's going to be very important, members of the board, when we get further down to a different section of Chapter 10. So now I'm going to go to Chapter 10-6I. And please remember, I'm quoting the chapter. I'm not merely advocating for a client, and I'm not merely suggesting to you what should be. I'm going to quote from the code. So at Chapter 10-6I, and I'm sorry, I'm on an iPad or a Kindle and I'm trying to get there. It reads as follows: application for a permit. Now we're talking about an electrical permit. So what is required to apply for this electrical permit? Quote, "To obtain a permit, the applicant shall first file an application in writing on a form furnished by the Department of Development Services for that purpose." We know that that occurred. DSD has already talked about that in its position statement. Such application shall, and then if you go to subpoint 2, it reads, "Describe the land on which the proposed work is to be done by legal descriptions, street address, or similar description that will readily identify and definitely locate the proposed building or work." Now when we go to 10-6K, this tells us what the action by the department is supposed to be on this application. The building official, and we know that that's the Director of Development Services from the first section I quoted, shall, and shall in law says must occur. There's a duty that must happen. It shall examine or cause to be examined application for permits and amendments. Such applications may be reviewed by other departments. If the application or construction documents do not conform to the requirements of the pertinent laws, the building official shall reject application in writing stating the reasons for rejection. If the building official is satisfied that the proposed work conforms to the requirements of this chapter and applicable laws and ordinances, and that fees are specified in ordinances adopted by the city have been paid, then it goes on to talk about how the permit shall be issued. It's very, very clear from Chapter 10 that this permit cannot be issued unless it is completely compliant with all law, including Chapter 35. Now, so this board knows, it is not us that requested to be before this board. It is the city that denied our application to be before the Board of Adjustment and suggested that we come before this board. And so we are here. But there has been one effort by my client, Ms. Rojas, to be before the Board of Adjustment, and the city refused to set the matter before the Board of Adjustment. And now we are before this board. And so what we are going to have to do is we are going to have to look at what other laws are applicable and are they compliant for purposes of allowing this electrical permit to even be issued, which I think sort of goes to your question earlier about the cross-references and whether or not the matter needs to be reevaluated. Oh, there's one. I was about to hand this instrument back to my colleague, Mr. Brad Wheeler, who's co-counsel on this matter. But there's one other point I would like to make on Chapter 10 before I start going into what we see as some of the problems. If you look at chapter or section 10-14A, it's referencing the creation of this board. A building-related and fire codes appeals and advisory board, also known as the Appeals and Advisory Board, is created. The board shall hear and decide appeals of orders, decisions, or determinations made by the building official or the fire chief relative to the application and interpretation of Chapter 10, Chapter 11, and specific articles in Chapter 28 of the City Code, and in order to provide advice to the building official. And it goes on from there. This is important because we already know that Chapter 10 is cross-referencing the need to ensure compliance with all other applicable laws, and that is Chapter 35. So this board clearly has authority to be reviewing this matter. And I would like to go through the crux of what we see as the problem, but before I do, I'd like to make one other point. I believe it's been alluded to, Mr. Murphy has discussed it, that there have been other matters on this very issue. With a different client than Ms. Rojas, Ms. Thelma Franco is currently, I'm representing her in litigation against the city on this matter. And there are a whole host and panoply of issues regarding that. But what I think is important is that the city attorney's office is representing the city of San Antonio in that litigation. Now, as a lawyer, it causes me some concern when that same office is advising the judge, and honorable members of the board, today you are the judge, is advising the judge on a position that it is also serving as an advocate in related litigation. I don't know if they follow their conflicts of interest provisions within their office to create firewalls. I don't know. But as I said earlier, citizens of this great state and of the United States of America have a right to have peaceful resolutions to disputes, and they have to be fair. And they not only have to be fair in fact, they have to have the appearance of fairness. So with that said, I think you are going to be fair, and I appreciate your time on that. So let's get to the heart of the matter. You have the appellate packet in front of you, from what I understand from DSD. And so rather than take you through line and verse of what some of the issues are, I would prefer just to talk about concepts, and then I'll entertain questions if you have them. The location is 2140 Babcock. At that location, there used to be a medical office building. That medical office building is approximately 22,000 square feet. I think it was built and predates the current UDC, Unified Development Code, under Chapter 35. It appears to have once upon a time been zoned as B1. Now, we're probably going to be litigating at some point whether or not the conversion matrix in the UDC actually complies with another statute called Chapter 211 of the Local Government Code. We're questioning whether it does, but that's a different story. For purposes of this hearing, the city believes that it is currently zoned as C1. And so, just for the sake of argument, let's take the city's position on that and see what are the requirements to be zoned as a C1 for the work that's being done here. I know it's a politically charged issue, but what is being built at that location is an abortion facility by Planned Parenthood. There's an abortion facility being built down the street also from this location. There's not litigation on that matter because there does not appear to be an immediate problem with any of the zoning issues. At this location, there appears to be, at least from the perspective of my clients. So what are those issues? Well, if you are in a C1 zoning district, you are limited on the type of uses that you can have. That's a low-intensity commercial use. It's our position that the UDC use matrix for commercial properties does not identify at all an ambulatory surgical center or an abortion facility on where it can be placed. However, if you're looking at a materially similar use, it would be most similar to a hospital. And so from the UDC matrix, I believe it's table 311-2, it would appear that the lowest intensity district in which this facility could be placed is a C2 or higher, not a C1. This location borders a subdivision known as Dream Hill Estate Subdivision. The Dream Hill Estate Subdivision is a rather eclectic subdivision, and you'll probably hear some testimony from a couple of people about that shortly. But just to give you a preview, that particular subdivision has large acre lots. It has all types of nature. It's almost a rural subdivision surrounded by the urban setting of San Antonio. Values of homes range from between 200,000 to a million or more. So it is truly an eclectic community. It is very clearly a community that seems to be what council was talking about in yesterday's B session in terms of trying to have a community that has a very mixed use, very eclectic, not just cookie cutter homes, not of any type. And so it's a very nice community. And it's bordering this location. There are concerns about traffic. There are concerns about congestion. There are concerns about property values. So under the UDC, and it's in the packet, and in particular, I would reference you to a letter I did for one of my other clients. Her name is Thelma Franco, and that's the letter that is in this packet because we did an incorporation and we cross-referenced what was contained from that packet and incorporated it here because it was germane. The use issues are that there is absolutely no use for an ambulatory surgical center or an abortion facility in C1. And for that proposition, I'm going to submit to be included in the record a letter from the city dated December 22nd, 2014, addressed to Sandra Garant and signed by Trenton Robertson, a senior planner. It is a letter, I'll just read it verbatim, if you'll permit me. To whom it may concern. As of the date of this letter, the above referenced property is zoned C1 AHOD, Light Commercial Airport Hazard Overlay District. The current C1 base zoning district resulted from the zoning district conversion that accompanied the adoption of the 2001 Unified Development Code. Ordinance 93881 dated May 3rd, 2001. The current C1 base zoning district changed from the previous B1 business district, which was established by Ordinance 75863 dated May 28, 1992. The use of a professional office and laboratory testing are permitted uses within C1 base zoning district. However, cold storage, medical surgery facility, and a hospital are not permitted uses within the C1 base zoning district. That's the pertinent part. There are two other paragraphs talking about contact information and cross-references to law. Do I hand this to you for inclusion in the record? Thank you. And so she has that letter if you'd like to see it. I understand it's now part of the record. So the city's position is, on December 22nd, that what is being allowed to be placed there should not be there. That's the city's position. And yet these permits were still issued. And respectfully, that's just wrong. Now, what is the effect of this? We are still trying to understand the city's position. But let's be candid about something. Most zoning problems can be fixed. They can. But there are different ways to do it. You can interpret away the problem and prevent a zoning hearing. You can interpret away the problem and prevent notice that would be required to be sent to residents or property owners within 200 feet of this location. You can do that. Or you can go through a proper process and have a zoning hearing if the applicant really wanted to change zoning to C2, and then have a hearing, a zoning commission hearing about whether that should occur with transparency and proper notice to the citizenry. That did not happen here. That did not happen here. And I'm not trying to impute motives to anybody. I'm just stating the facts. Okay? And so we are where we are. And so what we are asking of you, honorable members of the board, is to take a look at the packet that we have submitted and to please understand that the use of this facility that is being proposed does not comply with Chapter 35. And we know from Chapter 10 that before even an electrical permit can be issued, there must be a cross-reference and an adjudication of compliance with all other applicable laws. That does not exist here. One final thing I will state. The city can probably do this better than we can because of the city's systems. But we have made an earnest effort to try to ascertain every ambulatory surgical center in the city of San Antonio and what their zoning has been and is. I have a list here that I'm also going to include with the records if you'd like to see it. The short of this list is that it appears that historically, with a couple of outliers, and I'll explain those in a second, every ambulatory surgical center in the city of San Antonio has been C2 or C3, not C1. It has been at a higher intensity use. And I believe that there are either 71 or 72 locations on this list. Now, the C2 or higher would indicate that the city has traditionally treated ambulatory surgical centers, and the higher uses, probably equating them to hospitals. That's our position anyway. The other thing I would point out, because I've used two terms, I've used abortion facility and ambulatory surgical center, and it just dawned on me that someone might wonder why the two terms. An abortion facility and an ambulatory surgical center are licensed uses by the state of Texas. Even though the city has not placed that use on its use matrix, it is a use that was created by the state of Texas and has to be licensed by the Texas Health and Human Services Department. And it's governed by the Health and Safety Code, by the Texas Health and Safety Code. And what the legislature has done is it has now said that an abortion facility must meet the same licensure requirements as an ambulatory surgical center. So the reality is an abortion facility and an ASC are basically, when you're talking about an abortion clinic, are synonymous. A couple of outliers on this list For example, from what I understand, there's an ambulatory surgical center in the middle of the Northwest Christus Santa Rosa campus on the northwest side. And that is somehow zoned as C1. But there are some legacy issues on that, and it's in the middle of a campus, and the totality of the campus is either C2 or C3. It is not surrounded by residential. So it's for whatever reason, a legacy anomaly existed when they're licensing or zoning the entire Christus Santa Rosa campus. There's one other one that's an outlier on this, and I believe it was an ambulatory surgical center on the
South Coast.
Thank you, on South Cross. And what was fascinating is it looks like the line went right through the building. One half was C3 or C2, and the other half was a C1. And that was some type of legacy issue. It clearly wasn't intended to be that, and that location is even closed. But nowhere can we find an ambulatory surgical center in a C1 bordering a residential. We don't see that on this list. I'm now including this list to be part of the record. There are some other problems with the zoning of this building. For example, a C1 is limited to an aggregate of between 5,000, is limited to 5,000 square feet, possibly up to an aggregate of 15,000 square feet. This building is 22,000 square feet. And there are some other issues. But the heart of the matter is the use. The use is not compliant with a C1. And that means that when you look in Chapter 10 for the cross-reference to other applicable law, that the electrical permit should never have been issued. Honorable members of the board, I'll entertain any questions if you have them.
Mike Gross. The building official, you implied that his responsibility to check that all other laws, applicable laws, have been followed. And that implication seems to be that he has the responsibility and the power to re-adjudicate decisions of other boards. Is that what you're suggesting?
If you're saying, sir, if you're asking me if he has the power and authority to review his prior decision, yes, he does. Yes, he does. And if the question then is whether or not through an appellate process, that's another way to review it, yes, our position is that that can occur. Yes, sir.
Mr. Chairman, Andre here. One quick question on the application to appeal to this board. It does mention that the topic of the appeal is going to be UDC 35481 and City Code Chapter 10. Do you have any information on the appeal as it pertains to Chapter 10 this time?
In terms of the appeal before this board right now for Chapter 10?
Correct. Or is it only in the context of as it related to 35, I'm concerned?
Okay, I think I understand your question, sir. It is in the context as it relates to 35 based upon the cross-reference that I had referenced in Chapter 10. And Mr. Chairman, members of the board, I was just handed a note regarding the other facility that I was referencing that was being built. And I said that it appears that there are no zoning issues with that just down the street from this location at 2140 Babcock. I believe it's called Alamo Women's Reproductive Center, and it's in the C2. That is in the C2. Mr. Chairman, if there are no further questions, then I'll go ahead and take my seat right now, and I'm sure at some point my client would probably like to speak. Thank you, sir.
I do have a question for you.
Yes, Mr. Chairman.
It appears that you're contesting the electrical permit.
Yes, sir.
What about the building, plumbing, HVAC, and other permits? They're not contested, they're not being contested? And what's the reason for that?
Yes, sir. The notice requirements that I was talking about earlier are such that a number of citizens who are opposed to these permits from the Dream Hill Estates subdivision did not have direct notice of the issuance of some of these permits. So for example, the residents and the community became aware of this facility when news in San Antonio Express News broke October of 2014, not based upon receiving notice from the city. Now, I understand that the city's position is if you go ahead and research our website, you might find it there. And I appreciate that, and I understand the city's position. By the same token, the reality is you don't know what you don't know. And so if you did not know that what was being built was something that was violating zoning, you wouldn't know to be looking at the city's website to go through the rather arcane permitting listing on that tab of the website to go ahead and find it, is the short answer, sir. So the 30 days to have protested some of these other permits that you have referenced has elapsed, is the short of it. Any other questions? Thank you, Mr. Chairman.
Okay, we're open the floor now for citizens to be heard. We're open the floor now for citizens to be heard. Only those that have signed up will be allowed to speak. 4 people, you'll be allowed 3 minutes each. You cannot pass your time on to anyone else. First person that's signed up is Tina Luther.
Chairman, if I may, I'm going to go ahead and go to the mic. You'll hear a beep when there are 30 seconds left, and it'll sound like this. And then I'll let you know that there are 30 seconds left, and then I'll beep again when the 3 minutes are up, so that way you know that you have 30 seconds left.
I didn't sign because he said I was the appellant, so I didn't need to sign.
I'm sorry.
Sorry, if I may, my name is Lori Rojas, and I'm the appellant, and I didn't sign. Mr. Shannon told me I didn't need to sign since I'm the appellant.
That's correct. We discussed that before the meeting, and I believe if you would like to speak as the appellant, you can continue what was already presented with no time limit, and then everybody else would have the typical time limits. So if you'd like to do that, Mr. Chairman, I think that would be appropriate.
Please proceed.
Hey, I thank you guys for being here. My name is Lori Rojas, and I deeply appreciate this board. This is the biggest voice that we've been granted so far. So in order to answer some of your questions regarding the permitting process, I would have been rejecting every single permit that I could. I live in this neighborhood, and I believe that a completion permit to a fraudulent project is still fraud. So you close the end of a book, and it still is a bad deal for us. We have a small neighborhood. Our neighborhood's zoned R5, which is a low-density neighborhood. We have mixed incomes. The guy who mows most of the lawns in the neighborhood to one of the best doctors in the neighborhood live there. We have wildlife like crazy, but lately I haven't seen the wildlife because we have a lot of activity in our neighborhood. Our neighborhood has become much more traversed than it ever was before. If you guys could imagine your own neighborhoods and placing a sexually oriented business right at the entrance. So I have middle schoolers, I have elementary kids, and I've been talking to them regularly about what they're going to see. And that my middle school girls will see girls just like them on a regular basis. And they've asked, well, who's defending these girls? Who's looking out for these girls? Well, suddenly they become women. And that it's okay to be in a sexually oriented business in the middle of a neighborhood. So I looked at this and I started questioning, how could this happen? We've been very involved. We've been good citizens. We pay our taxes. We just got notice yesterday that our taxes are going up, but our property values are going down. So the concern there is that we have renters, we have owners, we have the accessory buildings. I don't know who was present at the city council meeting yesterday where they established a task force to look at these old neighborhoods. My house is from 1946. So, you can see that these are neighborhoods that are unique to the city of San Antonio. They're worth preserving the character of. But I feel like I'm being forced out. And I feel like I've been a good citizen. I'm representing many of my neighbors because many of them are senior citizens. Many of them have been in their homes for decade upon decade upon decade. And they can't be here because they can't get out of their homes. For example, my in-laws live just down the street from me, and they just retired in December, but they've faced a myriad of health issues. So this is causing a lot of stress in the neighborhood. Neighbors are drawing up swords against each other because they're taking it as a morality issue in addition to we've been neighbors, we've peacefully coexisted in this neighborhood for a very long time, and we have very different beliefs. But we can all agree that this is bad for our neighborhood. So completing this project will be bad for our neighborhood. It doesn't even have a sign on the building. When a new business comes into play, they proudly put up, here comes a new restaurant, get ready, they have lines waiting. There's no sign. They've never put up a sign. So people don't want this to be known. When I looked at their annual report for 2013, they have roughly 8 clinics, and they did, say, 1,200 abortions. They're going to do 2,800 at this one location. Well, this location is the entrance and exit of my neighborhood, and the only way to access this building is by going southbound. So the people who come to this location who are going north from 410 are going to be faced with a choice. Do they go down the street and turn around? Do they do an illegal U-turn right there in the city because they can't get in? Or do they take the easiest path, which is turn right into my neighborhood and turn around and come out? Now, the kind of clientele that usually frequents this building are full of bad characters. They're not the kind of characters that I usually want loose in my neighborhood. And they would not have discovered my neighborhood in any other way but coming to this facility. So we've typically had a very low crime rate. We're experiencing more calls than usual, and I only anticipate that to go up. These centers have been known to be bombed, to be shot. In Austin last month, there was a woman who threw a homemade bomb at women praying on the street. What can I expect from my neighborhood? What can I expect from my kids that are riding their bikes around the block? Well, they can't do that very easily if I don't feel they're safe. So I understood that the Unified Development Code was set up to promote health, safety, moral issues. And so when you start talking that a sexually oriented business is now backed up to residents' homes where there's a learning center just feet away, Easter Seals is across the street, Clarity Child Guidance Center is there, Northside ISD has an elementary on the back side of my neighborhood. So if I don't have a buffer, neither do they. So you got kids regularly walking in this neighborhood because they're part of the learning center. So it's easy for them to come and see our deer and the peacocks and, look at we have hawks. I had hawks stuck in my tree just last year. It's kind of a funny experience when you walk out and you see something hanging by its little talon, but this is the kind of urban oasis that we need to preserve. So terminating their permit is all I can see as a possibility because this place should not be located where it is. We have a neighborhood association and we've invited the businesses. We have many local businesses. We have doctors that back up to us. So it's never been a problem to coexist as a residence and commercial until now. And so what's happening is these guys could even be a part of my neighborhood association. And if you could imagine that for your own neighborhood, how could that be possible? And so there's many factors that have gone on, but I feel like what we're looking at here is a very national and international brand has moved their regional headquarters to my neighborhood, right at the entrance. And when you start looking at a national brand or an international brand, they're a business model, and a business model must grow. So if they have 8 clinics in 2013, and they're doing 1,200 abortions, and then 2015 they want to open up 1 in my neighborhood and do 2,800, where are they going to get these people? They didn't have them for 8 clinics, but now they have them for 1. So where are they going to park? Where are they going to drive? How are they going to get there? They're going to have to go in my neighborhood. So we're going to start having buses. I don't even have a full street length. Our streets are very, very narrow. It's old. We got the name Dream Hill Estates because we had estate-sized lots. We actually had the old characteristic for the name termination, or the name designation. So when you look at where do they go? Well, they're going in people's yards. Currently, right now, when people come in, contractors, protesters, anybody that's coming, they go in people's yards. So you've got property rights issues. People are getting up in arms over what's happening with their properties right now. They're not even open. And we've experienced a myriad of problems. And we've had, up until now, we've had very little voice. So what I would urge you to look at is, when you start comparing, is this the Chapter 10 issue? Is this the Chapter 35 issue? There's a whole lot that goes into this consideration, and this is the capstone of a project that shouldn't go on. They could be somewhere else in the city, rather than right there in the neighborhood. You want it to be pedestrian friendly, but if you think of Babcock and it's 6 lanes with 1 turn lane, it's really hard to be pedestrian friendly when you've got that much traffic going out there. One of my senior neighbors just a month ago was right there beside the Planned Parenthood trying to turn out. And because of the situation where there's a hill that comes up and over, somebody hit him. I mean, you've got to face these kind of issues when you're talking these old eclectic neighborhoods and talking about preserving them. Like yesterday in the city council, they said we need to maybe give some funds for people to relocate if they feel like the city has incentivized a building like this, because the city put in the sidewalk, so they've incentivized going into our neighborhood. And if they can, let's give them some, credits to get out of the neighborhood. But really, people don't want to get out of the neighborhood because they liked where they lived. They thought this was their retirement community. So even in our neighborhood, what we've done is we have a clubhouse that they're trying to turn into an education center that'll be for like multi-generational folks. So you've got your young kids to your senior citizens, but it becomes very difficult if you feel harm could come to you. And looking at some of these other neighborhoods around the country that have had this national brand, this international headquarters, they've had just clinics with it, but we're having a big location. And it's not zoned for heavy traffic. We have a low-density residential community, and we have low-density commercial next to us. So when you're talking about, kind of finalizing their project, you're finalizing something that shouldn't have ever been there in the first place. So putting kind of the completion of it all completes a bad project that the city still has an opportunity to say, no, this isn't right. This is not a precedent. We don't want this one to be the first of its kind. We don't want this to be precedent setting. So I strongly urge you to terminate the completion of this permit, the completion permit, and go back and review the other permits that were even issued. Because the city has that power and the teeth to do that. So I appreciate you for hearing my voice, and I urge you to reject this completion permit. Thank you.
Ms. Luther?
Hi, my name is Tina Luther. I live and work in the medical center. I live at 706 North Louise Drive in Dream Hill Estates. I actually have some photos that I'd like to show you. Is it possible to load them? So since we received word, and also the rest of the city has received word about the new facility at 2140 Babcock, what we have noticed is, of course, as my neighbors have been stating, increase in traffic flow. What I did also note, as well as other neighbors have noticed, we've seen an increase in crime as well. I went on the City of San Antonio's website and looked up the number of reported calls to police. So suspicious vehicles, suspicious persons has gone up. The pictures I'm going to show you, I'm sure y'all are all familiar with Fiesta and how things look with parking. Imagine your neighborhood looking like that nearly every week. Traffic has gotten so bad with people parking that if there were an emergency, there is no way an ambulance could make it down the street because our streets are so narrow. Also, what we've also been afraid of too, because of some people who are showing up on the site, there are children in the neighborhood. There's a daycare with 71 children, and they've been exposed to graphic images. The owner of the daycare was telling me that some of the children had questions in regards to what they were seeing. So there's also that issue as well. Of course, neighbors are worried about decrease in property value, but also along with that is damage to our infrastructure. Not just our streets, but water lines have been broken 2 times because of the parking and the street situation. So as soon as this image loads, I'll be happy to show you all about that. So this was taken in October. You can see at different corners of the street, the little round area, that's where 2140 Babcock is. So these are taken at different corners in October. During the week. This was taken months later in March, and there's a lot more traffic there. Still a lot of issues. One neighbor had an idea to put cones out in front of their yard to avoid that type of parking. We have police around because, of course, neighbors are calling and are concerned about what's going on. And the next photo is an aerial photo. So the 2 Ps that you see there, that's the location of 2140 Babcock. Then there's the daycare and the little house, that's where my neighbor Lori lives. And then there's the school. So you can see this is a very small neighborhood. All this is in close proximity to the clinic. So zoning laws are created to protect people, and that's what we're asking you as board members to enforce our laws and protect our neighbors and our citizens of San Antonio. Thank you.
Ms. Villarreal?
Good morning. My name is Sylvia Villarreal, and I want to thank you for giving me the opportunity to speak. I am a citizen of Bear County, and I'm come to the conclusion that you do not have the jurisdiction as far as the zone goes, and so I won't go over the facts of the zoning that this facility that we've spoken about would not allow body piercings, but yet it's got 2 operating rooms that will be infusing IV sedation and eventually general anesthesias. So I won't go over that because I know you don't have that jurisdiction. My biggest concern is that I think it's been a vortex for me, and since October I've been going into city council, and eventually it will be a domino effect, and there is such lawlessness going on, and city council chambers is not far from here. So I ask you to carefully review what is happening, because as far as I'm concerned, and I think everyone in this room with me, we will be the standing domino. So please review it very carefully, because there will be a domino effect. Take a real close look at it. In the months, about 6 months now, I've been going down there. There has been so much chaos down there, so much turnover in contractors. It's pretty frightening when we saw what happened at the Witchwood with all the passes or free passes they got. I feel like this facility is getting free passes, and that's of grave concern. And I have been there. I frequented, because I'm one of the people on the sidewalk praying for an end to abortion. It is a moral issue, but I know this is not something that I'm here to discuss this morning. My concern is to please carefully review this, because I see the city of San Antonio at this point on this project, on this, as being lawless. And that is very frightening, because we have a great city, we have a wonderful city that people are migrating here. Our growth is incredible, but we do not want to be a tourist attraction or promote abortion industry or be the city of abortion. So please, I ask you to look at it carefully. Thank you.
Mr. Goffel, I hope I pronounced that correctly.
Good afternoon. Good afternoon. Thank you. Thank you, Mr. Chairman. Thank you all. I have a hold of my letter in my hands here, a letter. This is a cover letter to the state of Texas from Delantero Investors. Delantero Investors. I don't know if it's going to be a bowling alley. I don't know if it's going to be a fancy Italian restaurant. But let's say I'm a citizen in Dream Hill Estates. Let's say that I am empowered by the website, our fabulous website of the city of San Antonio. I have no idea what that's going to be. Delantero Investors is Planned Parenthood. Now, if they do so much good, how come they hide their name? It's already been said that the sign's not even up. So certainly, we have been to the city council multiple times, and what they've done is they've kicked the can down the street. And you're in this position where they're daring you to do the right thing, the way I see it. I don't know why. I just know liberal governments like to kick the can down the street. I don't care if it's the federal budget or whatever. You have the opportunity, the unique opportunity to stop this. As Sylvia mentioned, when it comes to zoning, you just look at any of the matrix. There is no place in there as C1 for surgery. In this letter they went to the state of Texas, they brag about what they do. I'd like to read it to you real quickly. It consists of 2 operating rooms. The staff pattern of the ASC will include physicians, physician assistants, advanced practice nurses, registered nurses, licensed vocational nurses, and medical assistants. So they're tooting their own horn when it comes to the state to get that license. Then we've heard testimony at the city council where they're saying, oh, well, it's not really surgery. It's really not, we're just, just a clump of tissue. That's not a human being. We're being played as citizens. So how does a resident of Dream Hill Estate get justice? Well, you're it. Like it or not. Yesterday we heard testimony of the mayor's new plan. Just very quickly, I'd like to read a piece to you.
30 seconds.
Thank you. It says, the executive summary is a task force recommendations and divided into 2 goals that need to address the preservation of neighborhoods. First, to strengthen the urban fabric, and second, to begin creating mixed income communities. We have that right here. Maybe they wouldn't have to strengthen and revitalize communities if they didn't tear it down. And they tear it down by their bad zoning. So do the right thing. Thank you.
Bowen.
Good morning. My name is Patrick Von Dolan, and I'm here to zoom in on that letter so I can read as well as the top. There's a quote on the top that says that where there is no vision, this is a letter from Mayor Ivan Taylor, a recent letter. Where there is no vision, the people perish. If you'll come out, zoom out just a little bit for me. Where there's no vision, the people perish. Not that far. Where there is vision, the people perish. But he that keepeth the law, happy is he. That's from Proverbs chapter 29, verse 18. And I wanted to read that to you because that's the attitude of the mayor. And then there's a task force that met yesterday on housing. And it says their task force charge, you can see here, I'll submit it to as a document because it's taking too long to do that, but if you go and put this up for me. Task force charge is identify policies and programs that encourage investment in inner city neighborhoods, but minimize or prevent displacement of people or adverse impacts related to history, culture, and quality of life of unique neighborhoods. The city's talking about taking out a new bond and spending millions, hundreds of millions of dollars for revitalization to make sure we have dynamic and diverse neighborhoods. This is the Mayor's Task Force started by Julian Castro, continuing now. I would tell you, and I got letters here to submit to y'all of Dream Home Estates neighbors that are very concerned about the lack of preserving their neighborhood. And if you'll bring those up to me, I'll submit them to the board. I'd like to submit these two as evidence for you. This picture right here you see is the aerial view of Planned Parenthood's Del Lentero Investments Limited. Anybody know Spanish? Del Lentero is a Spanish word. You know what it means? It means a front, a facade. It's exactly what we're talking about here. It's fake. This is an abortion facility, an abortuary, some people call it. And houses on the street, you can't see them, but right across Beverly May, there's three houses right there, and within 50 feet from the back of that building are two residences adjacent to this, separated only by a fence and some bushes, some hedges. If you'll switch that to this, please. I have presented, you've probably seen this before. This is the DSD's own Unified Development Code training package that I'll present to you as well. It's September 28, 2009. This package was a training manual for everybody on the DSD website. This manual specifies in here what is the interpretation permitted uses are based on LBCS and NEICS. You probably know these codes better than I do. But yet, Michael Shannon and John Jacks in testimony on January 28th in a hearing, temporary restraining order hearing in front of Judge Saul Cassett, denied their even existence, even denied the fact they knew about them. They used the IBC, International Building Code, instead. Well, they're at odds with themselves. How can that be? So if you turn here and you go down to the DSB, and there's a material similar use, you're probably familiar with this. Well, Rod Sanchez, sitting over here to my right, has the ability to make a material similar use in certain situations. That's what's been made here, incorrectly, inappropriately, according to the letter by Trenton Robertson. So if you go to that website right now to try to find this manual, this training manual, it says, sorry, this page you're looking for is not found, can no longer be found. Now why is that? Why the training manual has been up there since 2009, all of a sudden disappear after March 20th, 2015, after depositions were taken of Trenton Robertson, former DSD employee? Why is that? I encourage you to look into it. You ought to know. You're on the board that deals with these people.
Good morning again. Center of Economic Services Legal. An issue has come up regarding video testimony. It's legal interpretation and advice that the chairman go ahead and rule whether or not immediate testimony can be presented. I'll advise the board that it is quasi-judicial. We have an opportunity, Government Services would have an opportunity, should have an opportunity to cross-examine those witnesses. Those witnesses are not available. So,
Mr. Shannon?
Yes, Mr. Chairman.
Proposed comments?
Thank you again, board, and thank you for everyone being here today that has spoke on the issue. As you can tell, this is a very challenging or hotly debated issue where there are some concerned people about this project. However, the issue before you all, and you as the board, the Building-Related Fire Code Appeals and Advisory Board, is very, very simple. So let's just discuss what they discussed, which was no reference at all to any electrical issues, electrical licensing issues, NFPA 70 as referenced by Chapter 10. None of that. Right? What they have argued is that there's this section of our code that catches everything. Well, if that were the case, if that was the intent of our Chapter 10 as they referenced, this board would hear appeals of historic preservation rulings, which is Chapter 35 also. Tree preservation rules, which is Chapter 35. Traffic design standards, how wide or long big a street needs to be. Flood issues that are flood design issues. Of course you don't hear those cases, right? So, and then I'll back that up by looking at section 1014 of our city code. A, actually, this was even partially read by Mr. Gruyard, I think I have that correctly. I'm sorry if I put your name, sir. In 1014A, the Building-Related Fire Code Appeals and Advisory Board, also known as the Appeals and Advisory Board, is created. The board shall hear and decide appeals of orders, decisions, or determinations made by the building official or fire chief relative to the application and interpretations of Chapter 10, 11, and specific articles in 28. So, of course, our code is very specific as what you should hear and decide upon. And you should hear, as your application addressed, that we issued a completion permit, a completion electrical permit, in March of this year. And in doing so, as I indicated, we verified the proper licensure, proper insurance. The design of the building was addressed back in August in terms of the electrical design and other trades. And also, everything you heard here that was addressed to you, the board, is zoning. The zoning issue was decided by the building official, i.e. Development Services, in August. Now, certainly that's not your purview to discuss. It makes it a complex issue for the neighborhood and the people here, but not for you. This is very, very simple. We issued a completion permit in accordance with all of our Chapter 10 laws to the right person, properly licensed, properly registered with us, properly insured. We do inspections to make sure that that person and that firm installs it in accordance with the applicable electrical codes, right? So that's what we've done. They are appealing that, and what they're trying to do is bring in things that aren't really related to you. And really, a lot of that was somewhat confusing because you don't have all the facts. He referenced what he calls facts, but that's not. There is a separate forum to debate those, which is happening. I think there was some questions alluding to that and how that would affect the board. It does not affect this board. This board is here to determine whether we issue a completion permit according to Chapter 10 to the right electrical contractor who's going to install it for the right electrical code as referenced by Chapter 10. So again, our contention is, of course, that we think we did this correctly. We believe the issuance of that completion permit was legal. It's in accordance with all of our codes. And all of the testimony that you heard related to zoning is intended to confuse the issue for you. Even some of the comments that alluded to our city attorney having some sort of impropriety because they're defending the city on a lawsuit against it related to this, but also giving you advice. The implication there that there's something fishy going on, none of that is related to this electrical permit. So, We ask that you confirm that the electrical permit was issued to the proper licensed, registered person or company in accordance with Chapter 10. I'd like to answer any more questions.
Thank you. Any questions from the board?
I have one
Shannon?
question, please. Jack Upmore, residential contractor. Mike, this might be superfluous, but if the original electrical contractor was still working on that job, would we be here today?
There would not be a new permit, meaning a completion permit, for them to have appealed. Whether they appealed in some other way, I don't know again. But I would suggest probably not, but that would be, I'm guessing at that. And to articulate even further, some of the questions were, again, there has been no change, right, into the design of the structure for this, let's say, electrical installation or electrical code stuff. I think there was a question related to that, but I'm assuming to answer your question that there's still no change of anything like that that we need in the contract.
Mr. Chairman?
Mr. Curley?
So, Mr. Shannon, if I'm getting this right, the building, is your position that the building department will issue a permit to anybody, anywhere, for anything, and zoning has never comes into play?
No, that's not my position.
So we could, I could get a building permit for a extreme case, a strip club next to a school, and the building department would issue that.
So, to fully answer your question, we would review the building permit, the proposed structure, the proposed new or improved structure, through the building permit process. That process has all types of different reviews: the building code review, the fire code review, the electrical plan examiner. We review at that time the proposed or current zoning. Is it in accordance with our Unified Development Code zoning regulations? All of that in this case, for example, happened before the issuance of the building permit in August. And then, as I indicated, our normal procedures at that point is because we have to ensure that there are licensed personnel installing it, right? Installing the electrical, mechanical, plumbing. The sub-trade permits are then pulled. Most of those, a high percentage, over a majority, I think it's somewhere up to the 70%, are pulled online. You may have used that yourself, where you can attach it and say, I'm the installing contractor, electrical contractor for the already permitted project that has already been issued a building permit for by the city, and that online system is created so that, from your desk at home or desk at the office, we verify your proper credentials as a licensed, registered, insured electrical contractor that's going to do that electrical work, and same for mechanical plumbing. So, again, there is, when we issue a building permit, there is a check for zoning through that process. Certainly in this particular case on a completion permit, we don't go back and re-review the fire lanes, the firewalls in the building, the exiting system, the zoning, because again, there's been no change, and we've already determined that back in the building permit. If they wanted to change something, meaning the design, the application, whatever, certainly our process is set up, we would go back and re-review that changed fire lane, that changed exiting system, that changed use, if it were. We have that set up if it does get changed. So that's my long answer to your short question, which is one of my specialties.
So at the beginning of in the plan, if I'm understanding it right, at the beginning of when they submit plans, that's when someone goes back and says, yes, this building fits in this zone.
Oh, of course, yeah. Zoning verification. There are a lot of Chapter 35, I'll call them Chapter 35 applicable requirements. I just alluded to them. Tree preservation and landscape requirements. If it's in a historic district, there's historic preservation. If it's in a special neighborhood conservation district, there are those type of things. So those are all part of our normal development services review process when we accept an application for a building permit, and then when we issue a building permit, as Chapter 10 will say, if we think it meets code, then we issue the building permit. The trade permits are just licensed people, appropriate people that are going to design what was on the design plans. A lot of times the engineer, electrical engineer designs it, and the electrical contractor will install it. So.
Mike, thank you for the explanation. You were describing the process if we were doing a brand new building. I understand that. and I know that there's all these under IB 103, that what you have to submit, and part of that zoning. In this case, it was an existing medical office building, which would qualify in a certain zoning. So my question is when they came in, was this parts of the building or the whole building that they were trying to obtain a building permit, which would then allow them to trigger and obtain trade permits?
The building permit process for this project, the applicant did submit multiple building permits. I believe, I don't have it in front of me, but I believe, for example, part of the first floor and the second floor, they divvy it up, which is not uncommon for renovation projects. But during that process, very clear, when you renovate a building and you're going to propose reconfiguration of the floor space or anything like that, we verify zoning as well as all the building code, fire code, electrical code, all that. So all of that has been reviewed not only for new projects, but a brand new building, but existing buildings as well.
And also there's a provision on that application for building permit when they come in to do that, to ask the question if there's a change in use.
Yes.
Okay. So on this case, was there a change in use?
There was not. This is a Group B occupancy for our building code, which it was and will be with the new proposed use. So we always ask the question, what was the old C of O's, if you will, what was the old legal use and occupancy? Use those terms a little interchangeably. And then what is it going to be? So we review that. We make decisions based on what is applicable in the zoning and or any other UDC and building related codes. And it was deemed that this meets the bill.
But if it was an ASC, an ambulatory surgical center, then that would be a change in use, because most medical office buildings are in a different zoning classification, different use category under Table 311.2 than what an ambulatory surgery center, correct?
Table 311.
Isn't that the use matrix in the thing? So the point being is that if you're in a medical office building, that's one use. The minute you introduce surgical procedures like an ambulatory surgical center, that's a different category of use.
What we have determined, and I don't have the use matrix in front of me, the city believes that this is allowed in both C1, what you described as a medical office and an ambulatory surgery center. It's both allowed in the C1.
I didn't think the ambulatory surgical center was allowed in C1.
It is.
Oh, okay, thank you.
And as I indicated, the further argument, clearly there's a debate on that issue, which is the zoning issue. That is being handled in another matter, of course not by this board. Again, if we were arguing tree preservation or landscape buffers and stuff like that, we wouldn't be in front of this board arguing that. What they're arguing is that we issued an electrical completion permit incorrectly, which of course is not the case.
Mike and McEckler. Did the footprint of the building change or the parking change?
I do not believe the footprint of the building changed. I would have to go back and look at the plans for parking. I don't have that in front of me.
Are there any other questions for Mr. Shannon?
Yes, I'm ready to read it. My question has to do with our reach back responsibility. I want to be crystal clear on what we're supposed to be looking at and when we are supposed to adopt milestones that allow us to go back and check something else. You gave some excellent examples of fire lanes. Somebody pulls electrical permit, they'll go back and do fire lanes. But if somebody were to pull a permit on a standard F1 occupancy and it turned into an H occupancy, then we would go back and look at fire lanes. And if that change occurred after some point in the permitting process, we would have some reach back potential to go back and say, well, now we need to relook at these fire lanes, or we need to relook at electrical and things like that. So my question is, if the reach back potential occurs, and in fact is sometimes encouraged by the city when we come across something like a fire pump that doesn't work, to go back and check other parameters of the building. What is that reach back potential between the IBC Chapter 10 and other city ordinances? That's the crux of my question, to kind of help us frame what we're doing here today.
Well, certainly, you may have all been involved with projects that there has been a change. The owner adds something, deletes something for cost, just decides on something totally different, that I want this instead of this. So when they change something, we, of course, as the city officials, building inspectors, or the plans examiners notified, whoever, whatever that change is will then dictate what we have to go back and take a look at. So for example, if they change the parking lot layout, for example, they wanted to add some more parking spaces or get rid of some parking spaces, that wouldn't necessarily have us go relook at the fire sprinkler plans for the building, right? Unless, for some reason, that the plans, maybe the underground water fire line, the water line coming into the fire line, was altered as part of that change, right? So those are clearly on a case by case, but our building, there's no question that our building code, our fire code, chapter 10, chapter 35, when something changes throughout the process, of course, we're going to go back and take a look at, is that change still compliant, right? So there are numerous examples of when that happens. So I would be here all day, I could probably rattle off 1,000 of them.
So really quickly, I guess then to summarize the city's position, there has never been a change in how the city looked at this facility. It wasn't a shell permit that turned into a finish out, that all of a sudden the finish out is the use that's starting to cause the concern. It was always this type of use, and you feel it was properly disclosed from the beginning.
Yes, when we issued our building permit, we knew as part of our plan review process, we knew this was an ambulatory care facility. Ambulatory care facility as defined, of course, in the IBC. As a Group B occupancy, we knew there was going to be surgeries. There are operating rooms on the plans, very obvious. So when we issued the permit, we knew what we were issuing. It wasn't that we learned later.
Mr. Russ?
It's Mike Russ. So I asked a question earlier regarding the reference to Chapter 10 where the building official had the responsibility to make sure the walls. And I guess can you just clarify for me, has the zoning issue been brought before any other commission or board to be ruled upon, or is it really the building official that made the decision on the zoning is the same building official, but not the same person, same office that issued the permit? And I guess one of my questions is asking if there's legitimacy to that point, if it's just the same person, or has it been adjudicated by another board? And you referenced also that it's being handled, and can you explain what that the zoning issue is being addressed by another board?
Right now, the zoning issue is not being handled by another board, but it is being handled through the litigation process.
So
I think one of our testifiers talked about a proposal for a temporary restraining order that they applied for. When I say they, I don't mean all of them. I mean part of who they represent. I don't know who it was. So there is another process where the zoning debate is currently happening.
So it's not an issue. It's not an issue of the building official issuing the permit because through other processes the zoning issue didn't be correct. The building official deemed it correct, and then therefore issued the permit based on that.
Absolutely.
Thank you.
Brian Smith. Had a question on, we were talking about different floors. Was there a master plan that was presented and then kept to, or were there multiple master permits that were pulled? You were saying the first story was done and then they went to the second story. Was it a master plan that had been done at one time and it wasn't changed, or did they start on a particular square footage or level and then apply for another permit, a general permit? Were there multiple general permits, or was there just one master general permit?
I don't have the permits in front of me, but I believe there are two separate non-master permits that were applied for, again, part of the first floor, and then I believe this is taking up most, if not all, of the second floor.
And what time period were these two permits pulled, and what was the review process once the second one was done? Because that can change, just as you were talking about before. Once you have one, you're evaluating there. You do another. Those are two different things. And I heard from square footages, this is pretty good size square footage.
Correct. Comparatively speaking.
Yeah.
So We issued and reviewed both permits. They were on or about, they weren't exactly the same day, of course, but they were in the same couple of months that we reviewed them, which was around the summertime of last year, 2014. The permits were issued in August of 2014, and we're well aware, as I indicated to Mr. Garcia's question, there was no question or change as to, when we issued a permit, what it was. We knew that this facility, which takes up some of the first floor and I think all of the second floor of this building, is an ambulatory surgery center.
Are there any more questions for Mr. Shanley?
Mr. Chair, Mike Leonard, I have a couple of questions. Mine regards the verification of the zoning when issuing a building permit. You indicated that C1 allows for ambulatory surgical center, and we have testimony from the appellant that says that it's not. How can we get verification of that?
Well, currently there's a process for that. There is an appeal process for that they are going through. The people that disagree with city staff, meaning development services, reviewed our codes, did our review of what it was, what it is, what we believe it meets the zoning regulations. So that's why we issued the permit in the first place. Clearly they disagree, meaning the part of the appellants is that what we heard. And we are going through litigation, I believe, right now on that. So how you would get verification as to who wins in the litigation, I don't know. I wouldn't even know what that time frame is going to look like.
My question is not referring to litigation, just the document itself. Is that document something that we should refer to in our hearing?
Okay. Mr. Leonard,
yes.
Chair.
Mr. Sanchez?
Yes, I'd like to introduce Susan Gwynn. There's a debate on, obviously, whether this is allowed in C1 or not allowed in C1. What we can show you is the process that we went through to come up with our determination. If that would help.
It would.
Good afternoon, Susan Gwynn, City Attorney's Office. I apologize, my copies are marked on. I was not really planning on presenting this to you. And I do want to reiterate that we do not believe that the zoning is an issue that's before you. But we are not trying to hide anything. I think you have some concerns, so we're just going to show you in very general ways how we got and made the determination. So, excuse my documents. Have to piece it together because if you make a copy of the code, only on the first page shows the zoning districts. We do not have a line in the matrix specifically for ambulatory care surgical centers. We heard a lot about a letter that was issued right before the Christmas break. That line is not in the matrix. And when you read PC regulations, it starts off in 35.311. If it's not in the matrix, it's prohibited. It's either there or it's not. But that's not the end of the story. Look in section 3. It goes on to say, I don't think anyone wants a code that lists every conceivable use. In fact, from time to time, we try and consolidate and have more general uses. We've never particularly had this issue arise before. So the director looked in the LVCS per the code, looked at the use matrix, and determined that it fit where medical, clinical offices were. It's not a hospital. It is more closely aligned with the medical clinic. And per the state statute, one of the defining issues is overnight stays for more than 24 hours. These clinics are not going to have inpatient care. They're not going to be long-term. That is one of the criteria. information that it was allowed in C1. That's not to say that some of these centers aren't in C2 zoning districts or C3. Most developments would like the highest zoning district possible. It increases the value of their property. They have considerably more expansive uses available to them. But it does not mean they can't go in other districts that allows them. Any questions?
Questions? Thank you.
Mr. Chairman, can I just add one more thing on that? Just to put it into a little bit more, again, Mike Shannon, just to put it in a little more context of what we're used to seeing with this board. In the building codes, for example, when we are classifying a building for the IBC, it falls into occupancy categories or occupancy groups. And many times, it's one of the things that are listed in that chapter, chapter 3. It typically says group B or something like this, and it gives 10 or 12 things to list. And most of the categories have something like that listed. However, we know that that list is not inclusive of everything and everything ever that will or be conceived by architects to be built or owners. And sometimes you have to interpret what it's most closely related to. That's a very common practice in the building code world, in your chapter 10 world, I'll follow from your perspective. And it comes up from time to time. So I think what she just described is the zoning version of that. As a director, sometimes have to make some interpretations, utilize it as guidance, and we're very confident that this meets really good.
Thank you, Mike. One last question, please. Mike, just so to fully understand the impending litigation on the zoning, will uphold or disallow our decision and all the previous permits issued on this property. Would that be true?
I don't know how to, you know what, I don't know how to answer that question. Let me maybe repeat that question.
I'm just saying whatever happens on the litigation that's happening will retro to everything that's gone on before and our decision that we come up with today.
I'll try. We don't know the answer to that. It will be up to the judge to decide if an error was made, and if an error was made, I'm sure they would tell us, they'd give us some options as to how to correct that error.
If there are no more questions, then we need to decide whether the city erred in their decision to issue the electrical permit or whether they complied with the requirements of Chapter 10 and issued the electrical permit. Is there a motion?
Mr. Chairman, motion for a 10-minute break and then panel discussion following that if possible.
We'll take a 10-minute break and reconvene.
I see. Happy Easter season to you.
It appears that everyone has returned, so we'll resume where we left off. I've been approached by a couple board members that have a question or two for city staff.
This is Mike Leonard. I'd like to follow up on the questioning I had earlier. In looking at the definition in section 35-A101 definitions and rules and interpretation, the city attorney had indicated that the city views this as a medical clinic, and under the definition of clinic, comma, dental or medical, the last sentence says, a clinic shall not include inpatient care or operating rooms for major surgery. That seems to conflict with what I heard earlier. I just want to get verification on that.
I'll take that. Okay. Well, again, I think as you're finding out, this is an issue of debate, if you will. We're confident about what is major surgery and not major surgery, what it most closely resembles, I think, with some of the other reference sections that you had. We agree that the ambulatory care facility is not listed in the use matrix, as Ms. Quinn indicated. So what we do is we evaluate all that are in there, and we put it into what it most closely resembles. And we believe we've done that, and we feel it's like that, and therefore permitted.
So it's DSD's position that this does not, this ambulatory surgical center does not constitute major surgery?
It's our position that we believe that our UDC allows this in the C1 zone.
Mr. Chair, Liddell Toy, I'm wondering, since this is in litigation, does our board have the authority to rule on this? Mr. Montford, do you have any?
You have the authority to determine whether or not the medical permit was granted in dereliction or wrongfully, as far as Chapter 10 was concerned. That's all.
And to help answer that question, Mr. Toy, is that when we receive any application to any of our boards on an appeal, we do a review to actually determine whether or not you have the ability to rule on it based on any of those factors. We wouldn't bring to you something that we didn't think you could rule on. And certainly electrical permits in Chapter 10 are on the record.
Now, I'm Ray Garabedian, so my question isn't specifically for Mike, but more for anyone with electrical background, I guess. Is there anything in the zoning, C1, C2, or anything other, that would change the rules of the electrical code? Something like clearly a dentist office, or clearly a physical therapist's office, non-intrusive procedures, versus a dental office or ambulatory care center?
I'll respond to that. In the electrical code, covers general construction requirements, and in Chapter 5, there are requirements for specific construction types. Specifically, Article 517 applies to hospitals. It's general requirements for hospitals. It doesn't go into details about CAT scan rooms or the various components that go into the hospital. It basically covers patient care areas.
So in the context of whether this is ambulatory care, a physical therapy type C1 use, or a hospital, our enforcement for Chapter 10 would kind of depend on what that is.
In the plan review, if it's designated as a hospital, it would be checked to see if it complies with Article 517. There are specific requirements for ASCs, but it's not in the city code or the NEC. It's in state codes, specifically GAC Title 25, Part 1, Chapter 135, Subchapter C, Rule 135.52. which was adopted by the state in June of '09, and that specifically applies to ambulatory surgical centers, new surgical centers, which includes adaptation of an existing building for a surgical center. Those are the rules that specifically apply to ASCs as imposed by the state.
Mr. Chairman, I think I may be wrong, but basically what he's saying is our code does not reference zoning. It's more the use of facility.
That's correct.
And I would help, excuse me, Mr. Chairman, I would help clarify, Mr. Garavinian, I know as fire protection engineer in the building code and fire code a lot, when we're designing the exit system for a building, we never ask the question, what's your zoning, right? We ask how many people are in there, how close are they to exits, those type of things. We don't ask if it's C1, C2, MF33, O1, all those zoning questions. Those are not tied into the building code regulations, and I believe what they're saying is the electrical code is not tied into that question either, which I think was your overall question.
Yeah, and I appreciate that. My concern with that concept is when there is a problem anywhere in the permitting or zoning process, at what point do we have a milestone to say now is the time to look back? And I'll throw this out there. It could be on a trivial, dare I say, continuation permit or certificate of occupancy or the original building permit, which is preferable, right? Or the original zoning request, which is preferable. I guess I'm going to have to think about when it's our time to say that there might be something in the past we need to look at. We don't want to exaggerate the problem any further beyond today.
Mr. Shannon, going back to the certificate of occupancy, which will be coming up at the completion of this project, at that time, does the department go back and verify that all the zoning is correct, everything is correct, before granting a certificate of occupancy?
Well, the normal process, when we grant a certificate of occupancy, or in this case, a letter of completion, because there's no change of occupancy, we issue, we determine that the project is over, you've passed all your final inspections, right? That's kind of what happened at the end product. We certainly don't go back and send the plans back to the plan review and review zoning and everything, because we're confident that's already been done. We know that, and in this case, it's been on the table through a lot of avenues like this, so we certainly don't reopen the books and say, hold on, business owner, let's redo it again. Now, if something changed, or if we found what we believe was an error, those things, yes, we would have to look at, but we don't believe that's in this case, and I would hate to think that that would be anybody's process.
I think that's the applicant's issue, is they believe that it was issued in error.
Oh, yeah, no, absolutely, that is definitely their, that is definitely their case. We, of course, disagree, so, and we believe that should be, debated through the proper channels, and it is being done through the proper channels, but that has nothing to do with this completion permit, of course, but, so that's why we're presenting on the completion permit, electrical permit, so I don't disagree with you to some extent, that they disagree with us, and we disagree with them, and that's being handled, but, that's not tied into this issuance of a completion permit, of course.
Mr. Chairman, that's one more thing.
All right.
I apologize for
I'm
belaboring.
down because the longer I sit here, thinking more questions.
This is going to be the last question.
And I apologize, it's somewhat of a hypothetical question, right? So this seems to be part of the crux of it is in Chapter 10, it says, all applicable laws must have been checked and applied to before we can issue the permit. Okay, so that's like the window into us having a reason to talk about it here today. And that issue is currently under litigation. So if a motion were to be made by this board to table this appeal, and that motion were to pass, what would be the result?
I would have to defer and maybe consult with legal because I don't know what that tabling of or what would that do to the timeliness of application. I'm not sure. I think it would.
As I'm rephrasing the question, as I understand it, Mr. Russ, you're asking if the board were to go ahead and make a motion and setting the motion to pass for tabling this issue, what would happen? Are you asking specifically for as far as the litigation issue is concerned, or as far as the impact on this particular decision?
Right, Mike Ross. No, I don't expect it would have any impact on the litigation, but the outcome of the litigation seems to be relevant to our decision, and so what would happen to the issue of the appeal of the Chapter 10 matters. We can continue on it. That motion hasn't even been made, so there's no reason to delay it further.
I apologize, I have to discuss here. As far as the tabling is concerned, Mr. Sanchez has granted that permit, so it would stand. I don't think any type of tabling of decision here would impact that. So it could go forward based on that.
I believe the question before us is, did the city act in good faith based on the information they had in hand and their interpretation of the rules of zoning? That's the question raised by the appellants. It's our duty and our responsibility to act on that information and determine whether the electrical permit is granted in violation of Chapter 10.
Mr. Chairman, may I respond for 2 minutes?
I'll give you 3 minutes.
Thank you,
Mr. Olivier, if I may take over the Development Services legal. This does deviate a little bit from the rules that the board went ahead and ruled on and adopted. However, I have no objections, as you said, you are putting a 3-minute limitation on that.
Thank you, Mr. Chairman, and I appreciate it. I know the board had a few questions of the city. I'm going to try to address a few of them because I have time limitations. First of all, regarding ongoing litigation that does not involve Lori Rojas, but involves someone else named Alma Franco. The board may not be aware of it, but the city has taken a position in court that for procedural reasons that litigation should be thrown out of court. So we disagree, but at some point in time, the merits of this case may never be heard in court. That's a distinct possibility. We don't know. It will be up to a judge at some point to decide. So when Mr. Shannon says it's being decided in another manner, maybe he's unaware of the position his lawyers have taken. But they have taken the position that the merits of the case never be heard in court. We'll have to see what happens. Regarding some of the questions that dealt with materially similar use under the code, Mr. Shannon and DSD have taken the position that an ambulatory surgical center is a materially similar use to an office building. Ms. Gwynn came up and was referencing to you a particular section, I believe it's 35-311 of the UDC. I respectfully submit, if you look at those sections, and it's contained in my letter, if you look at those sections, they identify the means and manner by which you do this. It's not just throwing a dart at the board. You look at NAICS and you look at LBCS. And basically, if you have more specific nomenclature than the general, you have to go to the more specific. So for example, in one of those two sources, you have daycare facilities that are one of the subsets of healthcare services that also include abortion facilities. So obviously, I don't think any sane person would be saying that a daycare facility is a materially similar use with an abortion facility. And for that reason, honorable members of the board, the UDC specifically explains how the director is supposed to do this. And so when you're looking at a much more specific use, you can't raise it back up to a much more general use, which is basically what they try to do. And so the reality is, even under materially similar use, our position is they're wrong. And the reality is a medical office building is not the same as an ASC. And in general, that's it. Thank you, Mr. Chairman.
Is there a motion from the board to either uphold the director's decision or to reject the director's decision?
Chairman, I think it's appropriate for board discussion to be crystal clear on our charter here. So we had an appeal that had a title page on it that said Chapter 35 and Chapter 10. We're told when we showed up today that it's only Chapter 10. So that put a giant tailspin on the research that we come to this meeting prepared to do. In light of that, the problem does get smaller, simpler, I guess. As a continuation permit for a project that, as the city points out, was clearly disclosed at the onset. We don't have any grounds for change or other light on this project. But my fear is that if there is a concern with the original premise for which the permit was issued, the zoning, and we continue that by allowing subsequent permits, again, we exaggerate the problem that occurred earlier.
As stated at the outset of the meeting, that we only have purview over Chapter 10. Chapter 35 falls under a different board. Our board members specifically or collectively have the expertise of the building codes, not the Unified Development Code. I'm not saying that some folks may have some knowledge of Chapter 35, but most of us have knowledge of the building codes and fire codes and electrical codes. And we're asked today to make a determination if the city erred in granting an electrical permit for this project that falls under Chapter 10. That's what we need to vote on today.
This is under there, it's a procedural question. Are there appeals to issuances of certificates of occupancies? This board hasn't heard one. I just wonder if that's an appealable decision from the Public Services Director and Zoning Code Official.
We would only be hearing appeals on the issuance of permits.
Though I had heard no reason, since we are only having, Robert Hanley, since we've not heard any evidence or reason that the City Development Services did not have the authority to issue the completion for the electrical permit, though I may have a different opinion about the decision made on the correct zoning comparison, I can't find any reason why we would find the Development Services in error of issuing that certificate for completion of electrical. So we'll fly this out and see if it gets approved. I'll make a motion to approve the decision made by the Development Services in issuing the completion of electrical permit.
Garcia? I will second the motion.
It's been moved by Mr. Hanley and seconded by Mr. Garcia that the board uphold the decision of the director on the issuance of the completion permit to for this project. All in favor, say aye.
Point of order, can we have some additional discussion?
Comment?
I don't necessarily have one, but it just is a point of order typically after the motion, the second line of opportunity.
Is there any discussion amongst the board members?
No, this is Tim Curley. I was having an issue with the flawed permit to begin with. And basically, if we follow this logic here, zoning doesn't matter. That's what I'm hearing. And so that once that decision's been made, they're telling us we can't go back and look at that. And I just have an issue with that. It doesn't sound right.
Well, Robert Henley, Ms. Curley, there's other boards that deal with that issue, and that's the disappointment, I think, to most of the members on this board, is that what handled differently, but that's not under our charter purview.
Well, if the building permit was flawed to begin with and was issued, then I believe it does follow.
Mike Leonard, I would agree with that premise, that if they're verifying the zoning when issuing a permit, it seems like it would be applicable to the issuance of this permit.
Or is there any other discussion before we vote?
Not regular meeting, so I took Mike's comments to heart there, that, we don't set a precedent of prior to approving a continuation permit, we all go all the way back to day one and check zoning. I think that's true, that's probably, we shouldn't do that, but when there is an issue brought up by a third party, is it our responsibility to go back when it's brought in front of us? That's what I've been thinking about for a while here, so I think that's worthy of thinking about before the vote.
Yeah. The questioning of zoning appears to be headed toward litigation, and that'll be resolved elsewhere. The issuance of the electrical permit is what we're here to discuss today. Is there any other discussion on the motion?
Mr. Chair, Liddell Toy, moving forward, is this board, if there's another incident like this, are we going to have to make a decision on this? Like, I don't want to be the scapegoat of the city. This is what this board is not supposed to do. Like you said, we're construction related, code related, we're not zoning related. So I'm afraid later on, moving forward, if other issues come up with another, facility like this or whatever, sexually oriented business, I don't want to be responsible. I'll help them, but I don't think that this is the issue for this board.
You're referring to the zoning issue?
Yes, sir.
There's no further discussion. We need to take a vote on the motion. And the motion is that this board uphold the decision of the director to grant the continuation of electrical permit for this project. All in favor, please say aye. Aye. All opposed? Nay.
No.
Okay. All those opposed, raise your hand. Is that for all four, raise your hand. Seven in favor of upholding, 5 opposed, the motion carries. The decision of the director is upheld. Next item on the agenda is board comments. Are there any comments from the board?
Yeah, just one general comment, and I alluded to many times. I think we were pretty ill prepared in the context of this meeting. I think we should be more descriptive in what the appeal entails. And when we're given material from the appellant that is completely, in the city's opinion, against what the meeting is about, then there should be some discretion as to what we're handed, because it was a really giant distraction. So, recommendation.
Yeah, I would like to get some guidance from city staff based on Mr. Leonard's comment and Mr. Garavina's comment that if a building permit is granted and part of that application process requires a lot of other notice and zonings, one of them, we need to sort of have a clear definition of whether that is part of the process for consideration for this board is what is that weight on? Because this is a technical building board, and when you go in for a permit, that's part of the smaller requirements. I'd like to get a clear definition of the separation of those and the importance of that in the decisions we make here as a board. That's all, Mr. Chairman.
Any other comments from the board? Staff? Is there a motion to adjourn?
So moved.
Second.
It's been moved and seconded that we adjourn the meeting. All in favor say aye.
Aye.
All opposed? Meeting is adjourned.